Okay, our first case on the docket this morning is 122532 Roy L. Bowens versus Greenwood County Hospital, Nancy McKenzie. And can I have help on the doctor as far as pronouncing his name? I don't want to mispronounce it. Is Diane Walters, or the attorney representing the doctor, is she here?
Yes, Your Honor, I'm here.
Would you pronounce the name for the record for me of the doctor?
Certainly. It's Dr. Petey Schwartfeger, and she goes by Dr. Petey if that makes things easier for today.
Yes, it will be. And Janice Anderson. So let me go through and get the appearances. Appearing for Mr. Bowens.
Jerry Levy and Catherine Kirk.
Who will be arguing?
I will, Your Honor.
Appearing for Greene County Hospital.
Peter Collins. I'm also appearing for Nancy McKenzie, Your Honor.
Appearing for PD.
Diane Waters.
Thank you. And appearing for Janice Anderson.
Matthew Saracti, Your Honor.
Okay, before we get started, I know that we have a number of defendants here. And looking at your briefs, it seems like you're pretty unified in your defense. Have y'all talked among yourselves as far as splitting the time? I know on your briefs you requested 30 minutes, but they've only assigned 15 minutes for this case. So have the defendants, have the counsel, have y'all talked as far as splitting your time?
Yes, Your Honor, we have agreed that I will argue for 11 minutes. Ms. Waters and Mr. Saracti will have 2 minutes apiece.
Now, Mr. Levy, are you ready to begin your argument?
I am, Your Honor.
Are we ready to hear it?
Okay, I'd like to reserve 2 minutes for rebuttal, please.
Okay.
Thank you. May it please the court, I'll lead off my argument with discussing the issue of jurisdiction that has been raised in this case. And in getting ready for this argument, I found some cases that I think take care of this issue. And it just so happens that none of them were cited by any of the parties. And the two cases are State versus Wilkins, W-I-L-K-I-N-S, at 269 Kansas 256, a 2000 case. And the case of State versus Griffin, which is 241 Kansas 68, 1987 case. And the Wilkins case very succinctly says, the notice of appeal should not be overly technical or detailed. The notice of appeal is not a device to alert the parties to all possible arguments on appeal. That is the purpose and function of the docketing statements and briefs filed by the parties. And the Wilkins case cited the Griffin case and as being precedent. So I believe that takes care of the issue of jurisdiction. In other words, the original notice of appeal filed in this case may have not been perfect, but I we were allowed to amend that notice. And we clearly believe that the docketing statements in the briefs fully set forth the issues to be decided on appeal in this case, and further believe that no prejudice has occurred to prejudice the appellees or defendants in this case. So with that, I'm going to move on to the, excuse me, I developed some chest congestion in the last couple of days, so I may be interrupting coughing every once in a while. I apologize. When the court below granted the defendant's motion for summary judgment in this case, the court cited only one case in support of its decision, and that was the case of Stormont Vale Healthcare Inc. versus Coutrere at 39 Canap 2nd, 2007. I'll call it the Coutrere case, was decided on a causation issue in which the plaintiff in the case was asking the court to consider the opinions in the expert's report regarding causation. But the court found in Coutrere that the expert witness completely disavowed his opinions. And they therefore said, the Kansas Supreme Court said, we're not going to consider the expert's report on causation because when his deposition was taken, he disavowed those opinions. Well, in this case, we are also relying upon the expert reports mainly the expert report of Dr. David Fairbanks. And the significant thing in this case is that in Dr. Fairbanks' deposition, he did not disavow his opinions. He, in fact, confirmed them and affirmed them. And his deposition contains numerous times when he was asked questions like this: have you now fully explained and discussed all opinions that you hold with regard to Dr. Petey? His answer was yes. And have you fully explained the basis for all those opinions? Answer, I have. And have you fully explained your knowledge about how those alleged failures of Dr. Petey caused injury or damage to Mr. Bowens? He answered yes. He was asked questions like that at least, I believe, a dozen times. And
Mr. Levy, let me interrupt you a little bit.
Sure.
Should this case have initially been pleaded as a lost chance of a better recovery action?
It could have been.
But you're saying it can be just treated as a regular medical malpractice.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
The arguments that we have seen as far as the defendants, they're arguing that because you're treating this as a regular medical malpractice case, in some of the cases that they cited, they're saying the jury would, if they found your favor, it'd be most likely they'd be pulling a figure, out of the hat. If they wouldn't have something, a strong foundation to base awarding damages to you. So what do you say to that particular argument that the defendants are making?
Well, if I can go back to the ruling of the trial court only ruled that Dr. Fairbanks could not say how much tissue was lost due to the negligence of the defendants. Well, what difference does it make how much tissue was lost if a jury would decide that tissue was lost because of negligence? They have the right to determine how much damage that was. But the problem is, in this case, the trial court did not consider all the other acts of negligence that cause different damages. For example, Dr. Fairbanks testified at length about those damages. For example, I'm sorry. He said that the negligence of the defendants led to misdiagnosis that was directly causative to Roy Bowens' spread of Fournier's gangrene and disabling groin infection and subsequent extensive surgery. That's the basis, enough of a basis for a jury to decide, okay, how much are we going to award for the non-economic damages of disabling groin infection and subsequent extensive surgery. The judge below did not even consider that. The only thing the judge considered was, well, the doctor couldn't say how much tissue was lost. Well, that wasn't his only opinion, and the court didn't even address the other opinions with regard to damages. For example, Mr. Bowens testified at length in his deposition about the fact that since this all happened, he's had no sex life. The judge didn't consider that as to whether or not Mr. Bowens had damages because of that. So the court just misplaced the use of the Couture case because the court below didn't consider all the other acts of or the other injuries. So I think it's it's clear that the evidence is there of causation, and Dr. Fairbanks did not disavow his opinions, which the judge below said would be the basis for not paying any attention to his expert report. The other thing Dr. Fairbanks did in his deposition was he affirmed the opinions of causation stated by the other expert witness for the plaintiff, the nurse practitioner, Miss Andreoni. Miss Andreoni testified and said in her report, these deviations from the standard of care resulted in the spread of infection and delayed definitive treatment for Mr. Bowens' Fournier's gangrene, resulting in prolonged pain, hospitalization, and recovery process. In his deposition, Dr. Fairbanks confirmed and affirmed that he agreed with the opinions of Nurse Andreoni. So there again, in his deposition, he didn't disavow opinions, he affirmed them. There is another very interesting dialogue that occurred in the deposition of Dr. Petey. In her deposition, I asked her, what are the symptoms of gangrene? And she gave me the opinion, the testimony of what the symptoms were, which included pain, fever, and foul-smelling discharge, and an abscess. And then I asked her, what is the treatment for gangrene? And she said, it is surgical. Now, Dr. Fairbanks has testified and given, and in his report, said that as early as the first day that Mr. Bowens was in the hospital when he was seen by Nurse Anderson, that there should have been an excision and draining of this abscess that Mr. Bowens had. And the other thing that is very important, and I urge the court to carefully look at nursing notes that were part of the Greenwood County Hospital admission of January 20, 2016, because after 2 hours in the hospital, it was noted that the pus was coming out of the abscess, and the nurse said, "It's very offensive smell." And then an hour or so later, the nurses note the patient's complaining of burning in the groin area and some foul smelling drainage. And it continued on and on and on. And I can tell you that was on the very first day he was there, when Dr. Fairbanks said that there should have been an excision and drainage of this abscess. Mr. Bowens lay in that hospital for 45 hours with this foul smelling drainage and offensive odor coming from this abscess. And all they did was basically change the bandages and give him morphine and Lortab and hydrocodone for the extreme pain that he was in.
Mr. Levy, before your time runs out, I'd like for you to talk a little bit about what the court err in striking the causation testimony of the nurse practitioner.
Okay, I'm ready to go there now, Your Honor. A nurse practitioner has standards of practice, and the Kansas law describes them. And there is a document which is called Standards of Practice for Nurse Practitioners, published by the American Academy of Nurse Practitioners, which was an exhibit in the deposition of Nurse Anderson. And it says that the process of care for a nurse practitioner is that they can assess the health status by attaining a relevant health and medical history, perform physical examination, perform or ordering or preventive and diagnostic procedures, identifying health and medical risk factors. The nurse practitioner can make a diagnosis. They can order drugs for treatment, and they develop a treatment plan for the patient, and then they follow up the patient to see after they implement the plan, and then they can recognize the importance of continued learning through participation in quality assurance review, etc. Sounds to me a lot like what a doctor does, doesn't it? So she is commenting on what Nurse Anderson could have done and had the authority to do. Now, it seems to me that if a nurse practitioner is allowed to make a diagnosis and to treat it, that they certainly ought to know if there's a bad result and if consequences have occurred because of improper treatment by a nurse. This is a nurse practitioner judging a nurse practitioner. And Dr. Andrioni, who's a doctor, she has a doctor of nursing, 40 years of experience. She has treated patients many times like Mr. Bowens. She testified to that. It's interesting that our courts have said that a nurse can testify regarding causation for failure to properly treat decubitus ulcers. Decubitus ulcers are an infection, and Mr. Bowens obviously had an infection, he had He had a abscess that was draining pus, a foul smelling odor, and was clearly an infection. So if a nurse practitioner or a nurse can give a causation opinion on the failure to treat one infection but not another, folks, that just doesn't make any sense. You know, my guess is that everybody who's looking on right now, who's on this screen, within the last few years has probably gone in to see their doctor, and their doctor was not available, so their nurse practitioner came to see you and made it and discussed your problems and diagnosed medication for you and followed up with your treatment. This is 2021. This is not 1921. Things have changed, and we, you know, years ago we didn't have nurse practitioners. Years ago we didn't have physician assistants. That has all changed. And
Mr. Levy, I've allowed you to go over a little bit. I'm going to let you have a minute to wrap up. Then you still will have your 2 minutes rebuttal.
okay, I just wrap up by saying, Your Honors, that I believe it's time to amplify the law of what a nurse can do with regard to causation. It's not the time for the status quo. Thank you.
Thank you. Mr. Collins, are you ready with your argument?
Yes, Your Honor, I am. Thank you. May it please the court. This court only has jurisdiction to entertain the plaintiff's appeal that was properly identified in his timely filed notice of appeal. In this case, the notice of appeal indicated the only issue or the only judgment or order of the court which was being appealed was the order denying plaintiff's motion to reconsider the order granting summary judgment. After then filing his docketing statement and receiving answers from all of the defendants, raising objections to issues raised in the docketing statement, did Mr. Levy file a motion to amend his notice of appeal to include additional issues. The issues included in the motion only included the motion for summary judgment, only added the court's ruling on the motion for summary judgment. It made no mention of the issue regarding the testimony of Nurse Andreoni. Furthermore, despite the fact that the motion was granted, there was never an amended notice filed. There is still, as of this day, no notice of appeal which would include the motion for the granting of the motion of summary judgment. Although Mr. Levy has cited two cases that don't appear in his brief, his testimony or his statement as to what those cases say do not get him over the hurdle, because those cases are considered in the subsequent cases of the Kansas Supreme Court, such as Weichman versus Huddleston or the Sedgwick County Board of County Commissioners versus City of Park City, in which the court was clear that only those issues raised in a timely filed notice are to be heard, and that it is not permissible for an appellate court to create a equitable exception to those rules. So that's our position with respect to the jurisdictional issue. However, regardless of whether you review the court's order regarding the motion for summary judgment under a de novo standard or under an abuse of discretion standard on the motion to the motion for reconsideration filed by plaintiff, you get to the same result. This is a classic loss of chance case. Dr. Fairbanks, Mr. Levy's expert, Mr. Bowens' expert, testified in his deposition that in the hours before Mr. Bowens presented to the Greenwood County Hospital Emergency Department on January 18th, he developed Fournier's gangrene. And Dr. Fairbanks testified that Fournier's gangrene is a surgical condition. So he testified that before he ever saw any of these defendants, Ms. Nurse Anderson, my client, Ms. McKenzie on the 20th, Dr. Petey on the 21st, he required surgery. The question then becomes, how much tissue was lost by the fact that the surgery was, in the light taken, in the reasonable inferences, and in the light taken most favorable to the plaintiff, by these alleged acts of negligence. And that's where Dr. Fairbanks could not meet the causation threshold for this case to go forward under the Delaney versus Cade case. In Delaney versus Cade, the court adopted the loss of chance theory of recovery. It expanded and provided the plaintiffs an opportunity to obtain recovery in a case such as this, where a pre-existing condition such as Fournier's gangrene that Mr. Bowens had before he came to the hospital, it allows that plaintiff to obtain recovery. However, in creating the cause of action or the theory of recovery of loss of chance, the Supreme Court reviewed the various methods by which a jury would award damages in such a case. And they considered, I think, 3 separate approaches, and they arrived on the middle approach, which they described as the proportional damage approach. And the proportional damage approach is essentially a balancing of interests. The court looked to a federal district court case called Booty versus United States, which is cited in our brief, which says that the proportional damage approach neither overcompensates the plaintiff nor unfairly burdens the defendant with an unattributable fault. And the proportional damage approach to damages in a loss of chance case requires the plaintiff to come forward with testimony as to what percentage of chance was lost by the alleged acts of negligence. In this case, Dr. Fairbanks was given several opportunities in his deposition to provide that. He simply stated he could not quantify the amount of tissue lost. He could not do that with respect to any of the defendants in the case. He couldn't do it with Ms. Anderson, couldn't do it with Ms. McKenzie, and could not do it with Dr. Petey. It's important, and this is a loss of chance case, because we don't know, without the benefit of the plaintiff creating this testimony, whether Mr. Bowens lost 5% more tissue, 10% more tissue, 20% more tissue, 30% more tissue, whatever. So what the jury would be asked to do if this case were to proceed to trial is to do what the plaintiff's own expert was not able to do. And that is arrive at an opinion and assess damages based on how much tissue was lost by Mr. Bowens as a result of these alleged acts of negligence. And the damages and other injuries that Mr. Levy referred to today are directly tied to that. So, for example, when he says Mr. Bowens no longer has a sex life, was that because would he have had a sex life? Would he have been able to have a sex life if surgery had been performed on the 18th or 19th? We don't know. Would he have had a sex life if it was performed on the 20th, 21st? We don't know. There's no evidence in the record on appeal and in the record, the discovery record, to support an allegation or to support a claim by plaintiff that using sex life, because Mr. Levy has used that, there's no evidence in the record to support that would have been any different if surgery had been performed when Dr. Fairbanks said it should have first been performed. We're asking the jury to simply guess and pull a rabbit out of a hat is the terminology that's been used in the cases. The jury simply would be left without any guidance as to award damages. And in adopting the loss of chance case, the Kansas Supreme Court was clear that that's not an appropriate basis for the jury to award damages. It just is as simple as the whole issue of causation is as simple as the plaintiff did not produce evidence of the percentage of chance lost by the alleged acts of negligence that would allow a jury to award damages using the proportional damage framework required by Delaney. If the case is allowed to proceed to trial, and if the jury renders a verdict, we will be right back before you saying there was not evidence to support the jury verdict, because under Delaney versus Cade, there has to be the percentage of chance lost expressed by the expert either as a specific percentage or as a range. So, and Delaney versus Cade was decided years ago. This was not a secret that in a loss of chance case where the plaintiff comes with a pre-existing condition that required surgery, that to survive a motion for summary judgment in a loss of chance case, the plaintiff has to have the testimony, expert testimony necessary for the jury to award damages on a proportional damage basis. So we think whether you decide the case on a de novo review of the order granting summary judgment or an abuse of discretion standard on denying the plaintiff's motion for reconsideration, which was treated by the court as a 6259F motion to amend judgment, you arrive at the same conclusion. The plaintiff simply does not have the testimony necessary to survive summary judgment in a loss of chance case. And this is clearly a loss of chance case because Mr. Bowens required surgery before ever seeing any of the defendants in this case. I will address the question of the admissibility of Nurse Andreoni's testimony briefly. Mr. Saracti will do that, and I just have 30 seconds. I would say that the court's order granting the motion to strike the testimony does not specifically state that it relies only on her designation as a nurse. It simply states she is not qualified to testify to causation in this case. He reviewed the testimony and the qualifications and made that determination. There is no indication in his order that he relied solely on her being a nurse as opposed to a physician. That is a determination that was should be reviewed on an abuse of discretion basis if it is reviewed, and the judge did not abuse his discretion in making that decision. I believe my 11 minutes is up. Thank you, Your Honors.
Thank you. Ms. Waters.
Yes,
You have
Your
2
Honor.
minutes.
Thank you. May it please the court. Mr. Collins has done a great job, and I don't want to reiterate or restate things that he has already said. A couple things I would add to what Mr. Collins has said is that, first of all, a loss of chance case has not been pled. So before we even get there, the plaintiff has to overcome the fact that they didn't plead this as a loss of chance case. So, and a negligence case even requires a heightened burden of causation proof than a loss of chance claim. So they have to get over that first hurdle of even being able to present a loss of chance claim before we get to the reduced burden on causation that's associated with a loss of chance claim that Mr. Collins has reviewed. The other thing that I would point out with regard to my client specifically is that Nurse Andreoni was not a designated expert against my client. And if you review summary judgment pleadings and the evidence that was presented in the summary judgment phase relative to my client, Nurse Andreoni and her opinions are nowhere in there. There's nothing relevant to that. Also, I would note that, and Mr. Saracti, I'm sorry, I don't want to steal your thunder, but I would note that there was an admission in summary judgment stage that Nurse Andreoni could not say, with regard to the criticisms she discussed in her deposition, to a reasonable degree of medical probability that they would have had any effect on the outcome. That was an admitted fact in summary judgment stage. So Nurse Andreoni, her testimony, her reports are irrelevant to my client, but additionally, she also failed to provide causation testimony. So that's all the additional things that I have to add over what Mr. Collins has already said. At this point, I would defer to Mr. Siraki. Thank you.
Thank you. Are we ready to hear from you, Mr. Siraki?
Yes, Your Honor, may it please the court. As dealing with the Andreoni issue, let's talk about that now. The court's order indicated that this case involved complex medical processes which are beyond the common knowledge of the average juror and Nurse Andreoni's qualifications. Mr. Collins touched on that a bit, and just to point the court in the right direction in terms of what Ms. Waters just indicated, she is accurate. In our summary judgment motion under Nurse Anderson's statement of fact number 48, it was uncontroverted by the plaintiff in their response, where she said that she cannot say with regard to the criticisms that she discussed in her deposition to a reasonable degree of medical probability that they would have had an effect on the outcome. That's kind of first and foremost. But the other common thread that we have here with both the experts that the plaintiff has presented, Nurse
I have a
Andreoni.
question.
Yes, Your Honor.
Why are the parties referring to the nurse practitioners as a nurse instead of as a nurse practitioner? I mean, it seems to be a limiting qualification because there's licensed practical nurses, there's RN nurses, there's BA RN nurses, and there's licensed practical nurses.
Your Honor, the only reason I refer to them as nurses, that's the way they've dealt with me. They don't typically address themselves by those elongated titles and all those other initials. They refer to themselves as nurses.
Oh, I'm just curious if there was a commonality in the case, because it seems to be a limiting disclosure about the qualifications of the various parties when one is a nurse practitioner versus some other form of a nurse. So thank you.
Yep. Now, the common denominator, though, between both of the experts is that they both, at times when pressed on their causation opinions, say they would defer to others. Nurse Andreoni said she would defer for a definitive cause to an infectious disease physician or a surgeon. The same was true with plaintiff's medical doctor expert, Dr. Fairbanks. When pushed during his deposition and asked about the tissue loss, he indicated the same thing. He would be more reliant and would defer to a surgeon in this case. And in this case, there were no surgical experts. Mr. Levy may address this in rebuttal. It hasn't been discussed yet. So I would point out to the court, in the disclosure of plaintiff's experts, Mr. Levy did identify two surgeons. Those surgeons were surgeons that were treating physicians. They were not retained. They performed the ultimate surgeries on Mr. Bowens. But in plaintiff's expert designation for those experts, they were identified again as non-retained experts. And they said they were designated that they would testify that they performed surgery on plaintiff based on the diagnosis of Fournier's gangrene. They would describe the surgery that was performed consistent with their operative reports, and they would testify about the post-operative care and treatment provided as shown in the medical records of their practice. Nowhere in those records is there a discussion or mention of what would have been presented by those folks. It was the plaintiff's opportunity to come forth at the summary judgment stage with evidence to set forth and show what that testimony would have been, and that was never done. So I just want to kind of address that in the event Mr. Levy wants to discuss the fact that he had named these two surgeons, because both his experts, when pressed on their causation opinions, say we would definitively defer to someone with a surgical specialty on the issue of the tissue loss. And I think Judge Ward, in his order granting the summary judgment at that point, where Dr. Fairbanks was the lone remaining expert, went through a litany of instances throughout Dr. Fairbanks's testimony and set forth all those instances, not just one, but a half dozen or more occasions where he said, I'm unable to tell you. I can't give you that information. I can't give you that opinion. And unfortunately, that's the deficiency that results in the summary judgment being granted here in favor of the defendants in this case. I don't think I've got anything further unless your honors have any questions. Thank you for your time this morning.
Thank you. Now, Mr. Levy, you still have your 2 minutes to rebuttal.
Thank you, Your Honor. Once again, I want to point out that the court below, in the decision on motion for summary judgment, decided only that Dr. Fairbanks could not testify as to how much tissue was lost as a result of the negligence of the defendants. Now, and as I've said time and time again, that is not the only claim being made by the plaintiff, being loss of tissue. The fact is, there are numerous other claims of damages to which Dr. Fairbanks addressed in his opinions. I've also noticed in the argument of the appellees this morning that none of them said that Dr. Fairbanks' entire expert report should not be considered. And the reason I'm sure they didn't say that is because he affirmed his report whenever he was asked about it. So the Couture case does not apply. And Judge Ward in the court below based his opinion or decision on the Couture case, which in fact was misplaced. Now, I have very little left to say, and I hesitate to do this, but I don't know whether you can see this or not. But this is
I can see.
You can see it?
Yes.
Okay. I'm not very much of an artist, but the surgeons who did the surgery on Mr. Bowens down in Wichita, they found that there was damaged tissue that at one place was measured 12 by 7 centimeters. And that's what this block on top represents. Then they said another area was 8 by 4 centimeters that they had tissue they had to replace. And that's this block. And that was done, that was on January 22 of 2016. Now, at the bottom there is a matchstick. You see the match head, the head of the matchstick there. The nurse who first saw Mr. Bowens on January the 16th to January the 18th, 2016, said the abscess that she was dealing with was the size of a match head. So this disease that Mr. Bowens had went from the size of a match head up to as much as this box up here, 12 by 7 centimeters. That shows the extent of the damage that resulted and would have been testified to by the surgeons who operated on him. And Your Honors, I thank you for your time. And if there are further questions, I'd be happy to answer them.
Are there any further questions of the judges?
No.
We do not have any further questions of the parties. We appreciate all your arguments. We'll take this case under advisement and get your opinion as soon as